Hello everyone, welcome to another series of To The Point. Today's topic of discussion is 50 years of Kesavananda Bharati Case. First of all, let's see why is it in the news. On April 24, 2023, the seminal ruling in Kesavananda Bharati completed 50 years. In this case, the Supreme Court laid down the basic structure doctrine on the limits of Parliament's power to amend the Constitution. Now let's discuss about Kesavananda Bharati Case 1973. In this case, the Supreme Court overruled its judgment in the Golaknath case. It upheld the validity of the 24th Amendment Act and stated that Parliament is empowered to abridge or take away any of the fundamental rights. At the same time, it laid down a new doctrine of the basic structure or basic features of the Constitution. It ruled that the constituent power of Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. This means that the Parliament cannot abridge or take away a fundamental right that forms a part of the basic structure of the Constitution. Now let's understand what constitutes basic structure of the Constitution. The SC did not define the term basic structure and only listed a few principles, federalism, secularism, democracy, as being its part. From the various judgments, the following have emerged as some of the basic features of the Constitution: supremacy of the Constitution, sovereign democratic and republican nature of the Indian polity, separation of powers between the legislature, the executive and the judiciary, judicial review, parliamentary system, rule of law, principle of equality, free and fair elections, independence of judiciary and limited power of Parliament to amend the Constitution. Now let's have a look at the scrutiny of the application of the doctrine. Since 1973, the SC has tested constitutional amendments against the doctrine of basic structure in at least 16 cases. In 9 of these 16 cases, the SC has upheld constitutional amendments that had been challenged on grounds of violation of the basic structure doctrine. 6 of these cases relate to reservations, including the quota for other backward classes and economically weaker sections, and reservations in promotions. The SC has struck down a constitutional amendment entirely just once, the Constitution 97th Amendment Act 2014. It established the National Judicial Appointments Commission. In 2021, a 3-judge bench of the court struck down a portion of the Constitution 97th Amendment Act 2011 but on procedural, not basic structure grounds. Just one of these 6 rulings involve an amendment that was not made during the Indira Gandhi era. In Quijotto Holohan dealt with the 10th schedule. Quijotto Holohan versus Zachilu and others, 1992. The SC upheld the Constitution 52nd Amendment Act that introduced the anti-defection law in the Constitution. Kesavananda Bharati, Sripada Gavalaru and others versus State of Kerala and ANR 1973. The court upheld the land ceiling laws that were challenged. However, it struck down a portion of the 25th Amendment 1972 which stated that if any law is passed to give effect to the directive principles, it cannot be deemed to be void on the ground that it takes away or abridges any of the rights contained in Article 14, 19 or 31. Indira Gandhi versus Raj Narayan 1975. It struck down the Constitution 39th Amendment Act 1975 which barred the SC from hearing a challenge to the election of President, Prime Minister, Vice President and Speaker of Lok Sabha. Minerva Mills Limited versus Union of India 1980. The SC struck down a clause inserted in Article 368 which said there shall be no limitation whatsoever on the constituent power of Parliament to amend by way of addition, variation or repeal the provisions of this Constitution. P. Sambamurthy versus State of Andhra Pradesh 1986. The SC struck down a portion of the 32nd Amendment 1973 which constituted an administrative tribunal for Andhra Pradesh for service matters, taking away the jurisdiction of the High Court. And L. Chandrakumar versus Union of India 1997. The top court struck down a portion of the 42nd Amendment which set up administrative tribunals excluding judicial review by high courts. Now it's time for the practice question. Consider the following statements regarding the Kesavananda Bharati case. 1. In Kesavananda Bharati case 1973, the Supreme Court laid down a new doctrine of the basic structure or basic features of the Constitution. 2. The SC did not define the term basic structure and only listed a few principles, federalism, secularism, democracy, as being its part. Which of the statements given above is or are correct? 1 only, 2 only, both 1 and 2, or neither 1 nor 2? Send the answer of this question in the comment section. Stay tuned for the next episode. Thanks for watching. Have a great day. Dear viewers, watch this topic in Hindi on our Drishti IAS Hindi YouTube channel.